A question we are frequently asked at Compass CHC relates to the time it will take to secure continuing healthcare funding. Now, the best thing to do is to break it down into the different stages that an application for continuing healthcare funding can take, and then talk about the different timeframes involved in each. So first and foremost, any client coming to Compass CHC does so first with a preliminary fixed fee investigation. What we are doing is gathering the independent evidence available from as many sources as we can to be able to determine that the individual is entitled to continuing healthcare funding when cross-referring that evidence to the criteria for eligibility. So in essence, we are looking at the carers records, care home records, any relevant GP and hospital records, and cross-referring it to the National Framework for Continuing Healthcare Funding, and determining whether there is the sufficient complexity, intensity and/or unpredictability in nature of need to determine that the needs are primarily health needs. This will follow the initial consultation that has been undertaken by telephone to check that there is the evidence to support the same initial conclusion that there is a case to be pursued. So, dealing with this point first, how long this will take will depend upon, in large, how long it takes to secure the independent evidence. Now, in law, the Data Protection Act 1998 states that a provider of medical information, health records, has 40 days to give us the records from the point at which the written request is made and the fee is paid. So you would assume that within 40 days we would have our records and we would be away. Now, in the best case scenario, this can often be the case, and sometimes it's swifter than that. However, we can encounter instances where the body holding the records can delay and, in essence, break the law in this area in not providing the records in a timely fashion. Equally as well, we can have instances where records are provided but they're an incomplete set, so we have to go back to the care home and say, well, thank you very much for the records you've given us, but we asked for records in their entirety, you've not given us the daily records, or you've only given us the care plans, or you've only given us a month from 3 years ago, when in fact we asked for the most recent 6 months worth of records. So there's all sorts of issues that can arise. There can be issues in actually the records being provided at all. Now, we have no, and this can vary, no reason to believe that any one particular reason as to why this can be the case, but care homes themselves perversely can be incentivised in an individual not receiving the funding simply because the private paying rates that they will be charged as an individual will often be far greater than the rates that the care home would receive from the NHS were the individual to have continuing healthcare funding. Clearly, in those set of circumstances, they are incentivised for the individual not to have the funding from a business perspective. Equally, we have experienced instances where care homes are a bit jittery about providing their records. They feel as though there is some implied criticism in somebody looking over their shoulder. This couldn't be further from the truth. All we are looking for is what issues this individual has and what care plans and structures are in place to deal with them, whether their needs are health needs. Nevertheless, these are the sorts of instances that can occur. Finally, and most frequently, some care homes treat such requests to provide records as an administrative burden they shouldn't have to fulfil. This is completely incorrect. The law is quite clear that as an individual that prepares records, should a request be received for disclosure of the same, they are obligated to provide them. However, some consider it to be over the top and they simply state they don't have the resources to provide the records. So time has to be spent explaining that actually in law they are obligated to make the time and that it's an expense that they must incur as a business much like any other. They couldn't say that they're not prepared to heat the building because it's too expensive. This is a business expense associated with the industry that they are in, and therefore they must adhere to it. What I'm trying to get across is that there are many different reasons why there can be delays in securing these records. As a company, we are experts in this area, and we have a great deal of success in working with providers to ensure that the records that we're entitled to are disclosed in a prompt and timely fashion. We have the administrative resources to be able to chase, badger, pursue, to ensure that we're getting the evidence that's available to assist in the application and securing of this funding. Equally, what I'm trying to get across is that there can be delays outside entirely of our control, and we will do everything we can to ensure that we advance matters as swiftly as possible. But nevertheless, these sorts of issues that arise can delay matters. but we have the team in place to be able to ensure that any delays are kept to an absolute minimum. Dealing with the next aspect of a case would be securing an assessment itself to be undertaken. Now, the national framework states that a clinical commissioning group has 14 days to complete an initial checklist assessment upon receipt of a request to do so. In practice, this simply does not occur. We have numerous instances of NHS trusts refusing to undertake assessments, stating incorrectly it's not their responsibility to undertake an assessment, or indeed reverting to us and saying that they're a bit backlogged and they'll deal within the next few months. Now, clearly that's unacceptable. The rules and procedures say that they must do it within 14 days, and again, it is an incentive for them not to do an assessment in this time frame, because if somebody ought to be in receipt of the funding and there is a delay in undertaking an assessment which confirms the same, clearly the NHS will not be paying for the funding for the time it takes for the assessment to be undertaken. And therefore, they cannot be allowed to delay unnecessarily when the rules and procedures within the national framework very clearly state that they are obligated to do it in a swift time frame. We have the team, we have the structure, we have the expertise as a company to be able to pursue the NHS and devote the time that is required to, in essence, badgering them into undertaking an assessment in the time frame that they should be doing it. Flowing from a checklist, there are rules that state that they must undertake, complete and give a report of an outcome for a full decision support tool assessment within 28 days of a successful checklist assessment triggering. Again, in practice, it can be far longer than this, and that's why it's necessary to have an expert in your corner with the time and resources available to be chasing to ensure that these timeframes are adhered to. Once again, there is no benefit for Compass as a company in matters being delayed. We are not paid on an hourly rate basis, as often can be the case with traditional law firm setup. We believe that we should not be incentivised for matters to be taking longer and dragging out. Indeed, under this system, any delays actually are a burden to us in the same way they're a burden to the patient, and we feel that's exactly how it should be. We want matters to conclude as swiftly as possible, and we will do everything we can to assist you in making sure that that happens. Dealing next with an appeal, again, there is no real set time process for an appeal to be undertaken. We apply the necessary pressure to the NHS to ensure that they are moving matters forward as swiftly as possible, and we will work with you to get across the fact that matters should not be delayed and press upon and press home the implications that such delays have from a negative perspective. Excuse me. As a further tool, of course, if it's necessary to take matters to NHS England as a final appeal point, the delays that have taken place and that cannot be justified are a weapon in one's armoury as a procedural impropriety point to be raised at an appeal. Once again, we will do everything we can to advance matters as quickly as possible because we appreciate from the family's perspective they do not want there to be delays. Dealing finally with retrospective cases for continuing healthcare funding, and this is where somebody has paid for care and they're looking for the funding to be reimbursed to them because they ought to have been in receipt of the funding throughout the time frame that they were paying. Now, this is slightly different to a continuing healthcare funding application on an ongoing basis, for the main point being that clearly the priority must be given from an NHS perspective to a living patient. We are dealing with someone who requires care on an ongoing basis, and clearly, whilst it's equally as important that somebody is reimbursed for care they ought not to have paid for, if the patient has sadly passed away, there is no pressing urgency in the same manner that there is for a living patient. The priority must be given to the living patient to ensure that their care needs are met on an ongoing basis. For this reason, retrospective continuing healthcare funding applications can take far longer than an ongoing continuing healthcare funding request for assessment. There is a limit on the resources that are available. There is no way around that, it's simply the reality, and therefore a significant delay it can be somewhat inevitable with a retrospective request for continuing healthcare funding, while they are in effect put to the back of the queue behind the present ongoing CHC funding applications. What is important is to gather the records as swiftly as possible so that they are not lost or mislaid, and to put forward one's case as soon as possible so that that clock is ticking And we know then that at some point in time in the future, in the following preceding months, the matter will be looked at. What I would suggest is it's important not to leave matters thinking, oh well, it's going to take them 6 months, 9 months to look at it anyway, so we won't bother doing it for 6 months, 9 months. Because the key factor is that in that intervening time frame, the records could be mislaid. So the evidence upon which you rely to support your case for CHC funding could be lost forever. What I would suggest is that you dig in, get the records necessary, prepare your case for retrospective funding and submit it, at which point it will then be in a process, in a clock will be ticking towards the NHS eventually looking at that and giving you an outcome. A lot of information has been relayed today in relation to timeframes. What I would suggest is if you have any questions regarding continuing healthcare funding and how we as a company may be able to assist, you should not hesitate to contact us directly. You can speak to one of our experts by telephone on 0121 227 8940. Alternatively, our website holds a wealth of information at www.continuing-healthcare.co.uk. Thank you.